else is done.
So
And then,
yeah,
I don't know.
taking our seats.
Which end would you like? I usually sit in the middle.
I have to sit in the middle.
Good morning, everybody, and welcome to day 2 of our hearing on internet communication disclaimers and definition of public communication. So today we will start the morning with panel number 4. We have Christine Bannon, Administrative Law and Policy Fellow from the Electronic Privacy Information Center, Doug Hochberg, Chief Digital Director, Republican National Committee, Chris Nolan, Founder and Chief Executive Officer of Spot On. Welcome to all 3 of you. Thank you for coming. So the way we're going to do this is each of you has an opportunity to give a 5-minute opening statement. The yellow light will go on when you have 1 minute left, and when the light turns red, you can just start wrapping up your comments. That would be great. So we'll go alphabetically and start, please, with Ms. Bannon.
Madam Chair, Vice Chair, and members of the Commission, thank you for the opportunity to testify today. My name is Christine Bannon, and I'm an attorney at the Electronic Privacy Information Center, known as EPIC. EPIC is a public interest research center established in 1994 to focus public attention on emerging privacy and civil liberties issues. I want to begin my testimony by stating a simple principle, that users should know why they are being targeted for an ad and who is paying for it. Some commenters have argued that there is a fundamental difference between internet advertising and traditional advertising that justifies lax disclosure requirements for online advertisers. I agree that there is a fundamental difference between online ads and traditional ads. The difference is that online ads can be micro-targeted by gender, race, sexual orientation, religion, income, and anything you've ever liked online. However, this requires more scrutiny from the FEC, not less. At the very least, FEC rules should require at least as much transparency for internet-based advertising as they do for traditional print and broadcast advertising. For this reason, Alternative A is a stronger proposal. Whenever feasible, ads should include a disclaimer on the face of the communication stating who paid for the ad. This should be the default because it will ensure that everyone who sees the ad will also see the disclaimer, as is the case for ads on traditional media. Alternative A allows adapted disclaimers when a traditional disclaimer would not be feasible, using technological mechanisms such as links and pop-up screens. Disclaimers that require users to navigate to a different screen should be disfavored, because the vast majority of internet ads have a click-through rate of less than 1%. Therefore, if an ad requires users to navigate to a different page to see the disclaimer, less than 1% of users will see the disclaimer. This should be the exception, not the rule. If the FEC adopts the exception in Alternative B that allows advertisements without any form of disclaimer or indicator, it would undercut the rest of the rule. While it's true that there may be future forms of advertising that are incompatible with the technological mechanisms for adapted disclaimers contemplated now, this does not mean that there will not be other technological mechanisms for disclosing information to users. Alternative B relies on this false premise, assuming that future ads are not well suited to current adapted disclaimers, like hover-over mechanisms or pop-up screens, will therefore be completely unable to include any form of disclaimer. As long as the FEC does not mandate the specific types of mechanisms that can be used for adapted disclaimers, ad tech companies will be able to develop new types of disclaimers compatible with their innovative ads. Alternative B's exception will discourage advertisers and internet companies from innovating new methods of disclosure. Companies that are innovative enough to develop new methods of advertising are also innovative enough to develop disclaimers compatible with that technology. The FEC should not remove the incentive of companies to develop less burdensome and more effective methods of disclosing the funders of political ads to users. Advertisers are experts in capturing the attention of internet users, and they should use their expertise to disclose important information to the targets of their ads. The Supreme Court has held that the government's informational interest is sufficient to justify disclaimer requirements, even when a speaker claims that the inclusion of a disclaimer decreases both the quantity and effectiveness of the group's speech. Therefore, arguments that the FEC's proposed rules would burden the effectiveness of the ad are insufficient to justify changing the disclaimer requirements. The government's informational interest to prevent corruption or the appearance of corruption is even stronger for internet advertisements because they are micro-targeted. The FEC should not abrogate that interest. Disclaimer rules for internet communications are necessary to protect transparency in campaign advertising expenditures. However, in order for these measures to be effective, advertisers should also be required to disclose how they are targeting political ads. Algorithmic transparency is the public's right to know how they are being targeted and by whom. Advertisers are able to reach users based on the intimate details of their lives in a way that is not possible with traditional media. Because of this, voters should know why they are being targeted for a particular message. Now more than ever, it's crucial that Americans are able to trust the political ads they see online. EPIC urges the FEC to finalize a rule that requires disclaimers that provide at least as much information to users as the rules for traditional media require, and does not allow an exception that allows some ads to evade all types of disclaimers. Thank you again for the opportunity to testify, and I'd be happy to answer any questions.
Thank you very much. Mr. Hochberg.
Madam Chair, Madam Vice Chair, Commissioners, thank you for inviting me here to be able to testify on this. My name is Doug Hochberg. I am the Chief Digital Officer at the Republican National Committee. You have my written testimony, so I just want to cover a few basic points from there and then happy to answer any questions afterwards. The first is that I want it to be very clear. I want people to know who is buying the ads that they're seeing online. That is a goal that I think every good advertiser wants to have in the political space. We may come to different conclusions on how to display who's paying for those ads, but at the end, I want the user to have that ability. Second is, I really do recognize that this is a very difficult task for you. The rules that come out of these hearings have to be able to be used for 5 to 10 years in the future, and we don't know what type of ads were going to be available 5 to 10 years from now. If we look back 5 to 10 years in the past, ad types that I use today to for get out the vote campaigns, for persuasion campaigns, those weren't available back then. So to create new rules that are going to be used in the future, I think there's a couple things that we should take into account on that. First is that they have to be tech agnostic, meaning whatever we come up with, whatever you create as the new rules for us to follow, they have to be able to work on every platform that we currently use and platforms that we don't even know exist yet. So that is one piece of it, as well as having, and this is a new term to me that I've learned from these hearings and from our lawyer here, is bright line rules. I know it's a term you guys use a lot more. I know that term only from the results that I get from it usually, which is you can't run this rule, you can't run this ad because we don't know if there's a ruling on it. And campaigns have a tendency to move so fast, especially in September, October, November, that there's not time for an advisory ruling. And usually when the good actors on campaigns and in committees, if there's a question about if an ad will be struck down by the FEC, usually the answer is we're not going to run that ad. So to give us those clear rules of what's available to us is a very, very important piece of it. And then finally, that I think we're in agreement here, online ads are inherently different than TV, radio, and mail ads. Online ads give the user more of an experience. They give the user the ability to click, like, share, pause the ad, interact with it in ways that you don't get in TV and radio. And for that reason, I don't think we should be considering them in the same categories. For instance, if you don't hear the end of a disclaimer of a TV ad, or if you're looking down at your phone and you don't see that piece of it, if you mute your television during a commercial break, you don't know who ran the ad as clearly, and you can't go back. Maybe some people have TiVo and can rewind, but most people won't go back and rewind their television to see who ran that ad. On a computer, on your phone, when you're seeing these ads appear in front of you, you can click on it, You can scroll back up to see the ad. There's a lot of options that have the user, that the user has that you don't just have that ability on radio or television. And for those reasons in general, we would like to advocate for at least a one-click rule. And this is something that has been used as advisory opinions in the past, where the disclaimer for who's running the ad is never more than one click away from the user. And for us, this satisfies a lot of tech requirements. It doesn't put a burden on companies to develop other pieces that they don't have. And it doesn't put advertisers and users, the people who are buying the ads at this point, in a difficult situation of not knowing if a Facebook or Google or Twitter or any other ad company is going to satisfy a requirement for you that would then inherently make it unavailable for us in a new ad type. So I'm really happy to answer any questions you have on this and looking forward to the rest of the hearing. Thank you.
Thank you very much. Ms. Nolan.
Good morning, Chairman Hunter, Chairwoman Hunter, I'm sorry, and members of the Federal Election Commission. My name is Chris Nolan. I am the founder and CEO of Spot On. Started in 2008 and based in San Francisco, Spot On is a cloud-based ad buying platform for advocacy efforts and political campaigns across the country. Spot On works for a variety of causes and parties. Our clients have included oil refineries and environmental efforts, organizations backed by tobacco companies, as well as nonprofits interested in improving health care for undocumented California residents. We work for Republicans and for Democrats. We are here today as vendors with 10 years of market experience. As such, Spot On's written responses today are tailored to focus on the parts of the Commission's NPRM where we feel our experience can be the most help. Over the past 4 years, as political consultants and campaigns have come to understand the power of the internet and its ability to reach, and yes, target voters, Spot On has noticed a number of disturbing trends that we think will impact the Commission's effort in regard to this rulemaking. I'd like to highlight two today. The first is the widespread use of what's called programmatic or automated ad buying, which has brought the problems, confusion, and fraud rampant in the commercial ad tech ecosystem to political. Our experience in this arena makes Spot On unconvinced that any of the disclosure schemes that have been suggested by and to the Commission or Congress will have their desired impact. Our experience is that programmatic ad tech firms who handle the bulk of all online advertising treat political speech as another brand silo, to be trafficked as quickly as possible with minimal costs and maximum profit. Oversight is minimal and ignorance of the law is high. We have difficulty seeing how badges, written disclaimers, or other display requirements will be enforced in this laissez-faire environment. It's a porous system with multiple points of entry. It's frequently compared to high-tech stock market of today. There's one big difference. Wall Street has rules, lots of them. Ad tech has none. When it comes to direct buys or placements on so-called walled gardens like Facebook or Spotify, the environment is equally troubling. Outlets of all types are creating their own rules. They are defining what they think is appropriate political speech. They are often examining sources of website and ad funding using subjective criteria without regard to the law. Few exceptions are permitted, and it's often impossible to obtain clear written policies or guidelines beyond, oh, we just don't do that. Facebook's regulatory scheme imposed late last month, a week before the California primary, is a high-profile, very public example of this sort of ad hoc rulemaking. Facebook has imposed a series of rules separate and apart from those already required by state laws like California's. This has encouraged others to set their own rules, some of which we've outlined in our written comments. These decisions are somewhat understandable. None of these publicly traded corporations wish to endure the fallout from trafficking in unseemly election-related behavior. However, the brand-centric protection models they've come up with are not accompanied by an understanding of the nature and traditional legal protections afforded political speech. In short, we think a hodgepodge of often arbitrary rules is creating a chilling effect that we think will only snowball as we get to November. Given this environment, Spot On is suggesting that the Commission, and if necessary, other appropriate agencies, look not just at disclosures and disclaimers, but at the behavior of advertisers when considering how to structure future rules. Almost all, political and advocacy efforts trying to impact elections use publicly available voter registration information to help target ads. This is the one element all political campaigns have in common, and it's the one thing that sets them apart from brand advertisers. What if the Commission were to adopt a scheme where the use of this sort of data required publishers, ad buying, and selling platforms, and the walled gardens to segregate such advertisers from other brand advertising traffic? Once segregated, it would be easier and more effective to determine disclosure and disclaimer requirements for speech intended by its sponsors to be political in nature. This action would move us away from discussion about a regulatory scheme that, as my Republican colleague on this panel put it so eloquently in his remarks, puts form over function. There are many ad formats on the web, with more to come. Function, however, remains constant and can be easily monitored and tracked. If you're after voters, there are some rules for everybody. Using voter targeting as a trigger for special treatment by ad sellers would mean that political advertisers could be treated as they are when they purchase TV or radio or print ads. These advertisers would talk with salespeople and ad traffickers familiar with the rules and obligations that accompany the sale and carriage of these messages. This would certainly have a clarifying effect on the programmatic ad buying platforms, and it would set some baseline rules for others. This is by no means a one-size-fits-all remedy or even a solution for this very difficult set of problems that are in front of us. Spot On sees this data trigger device as a starting point, a framework, if you will, for a more thorough conversation about the use and abuse of paid political speech on the internet. We realize this is a very different perspective than what's been expressed by other panelists, but we feel it's worthy of consideration within and outside the Commission. Thank you for your time today, and I look forward to your questions.
Thank you very much to all three of you. Any questions? Madam Vice Chair?
Thank you to all the panelists. Ms. Nolan, can you spell this out a little bit more? Exactly what would this regulation look like?
Well, I'm not a lawyer, constitutional or otherwise, but I could make a few suggestions. When you go to purchase advertising, many, and Mr. Hochberg can talk about this, I think, in some more depth, more practically than I can, as a potential client, for example. When you go to purchase online advertising, you can do so in demographic buckets. This is what Ms. Bannon is referring to when she talks about micro-targeting. And as a result of that, your ads are directed to certain individuals. So, for example, I might be able to reach young women in their 30s living at Connecticut and Porter Street who are registered Republicans and give money to the ACLU, just to give an example.
I think that's a small bucket, but
Nevertheless.
that is micro-targeting.
Yeah, but when you do that, you have to purchase that information. Or you can bring it to your ad buying platform in what's called first-party data. So from people, email lists you've collected. So the idea is that as soon as you do that, as soon as your ads start to be accompanied by that information, which the ad platforms see, which a publisher would see, which I as a buying platform would see, you automatically aren't with the people selling cars and soda and cigarettes. You're with the folks who are trying to reach voters.
Well, I'm not sure about that, actually. I mean, I could envision somebody deciding that to use car data as an example. People who buy Priuses are...
That's already being done.
No, I know, but my point is, so how do you segregate, if you're trying to segregate out people who are targeting, advertisers who are trying to target folks for political ads, how do you segregate out the overtly, somebody who buys a voter registration database, which, that part is easy, from somebody who buys the database of people who buy Priuses, thinking that that is a good proxy for a certain type of voter?
Well, at one point in sort of thinking about this, I talked with an election lawyer. And I said, yeah, you're right. It's possible that someone, could just say, oh, I'm not going to use voter data to target my ads. And he looked at me and said, nobody's going to do that. And I have to defer to the Republican Party here, but I think the expression on Mr. Hochberg's face kind of tells you what you need to know. It is a fundamental tool. It is the one thing that separates what I do as a political ad buyer from the folks who are trafficking in Toyota Prius ads.
Please.
Since I was mentioned a couple times in that. Yes, voter data is very important in how we target, but consumer data, as well as you mentioned, is part of how modern political campaigns target voters still. I think one of the issues that you're going to run into with this is potentially how that data is mixed together. So a lot of times it's not just uploading a universe of people who have rented a Prius or bought a Prius in the past and combine that just, and that's a separate universe than people who have voted early in a primary. Those numbers are going to be combined together and then segmented out based on other factors. And the question is, how many different segments do you go through until it's no longer just voter data and consumer data, but this is a hodgepodge of all different information types, all different data that gets put into a system and then used as information. And I could see first-party data, as you mentioned, is when we own our own information and we upload these people. When we're buying, there's people who will buy lists and different segments and target it. I could also envision ad platforms and sellers of this information, if this is the case, and how you would have to report it, mixing up the data and not reporting it as a, voter data, but as a consumer type data with voter information and history somewhat in there. What's the percentage of the use case for me would be the issue. Because it's not as clean as it sounds. It's not every time, it's not as clean as that sounds.
But I'm inferring that what Ms. Nolan is saying is that at some point along the way, if you want to target voters, you're going to need this voter data. So, okay, so we start with people who are using voter data, who acquire voter data, and then we do what?
Well, I think the idea here is to segregate out someone who has political intent. And then I think you have, and I want to associate myself very closely with the remarks that were made yesterday by CDT and Tech Freedom, because all of us, I think, agree that what we have in front of us is a series of problems that are not going to be stopped or stymied or resolved by badges and disclosures and disclaimers. And I think someone went in to make fun of the arguments about typeface and contrast, et cetera. I'm totally with that. What I'm trying to do is say the problem isn't necessarily with disclosures and disclaimers as much as it is with the ways in which information flows on the web, and looking at how information flows and its intent speaks more to the heart of how the internet functions and how it delivers advertising to people than a disclosure and a disclaimer. Someone said yesterday afternoon that maybe we need to reframe this. Does an internet ad have a face? In other words, since it's a dynamic set of code that goes to someone and sits on a computer screen, what is the face of an internet ad? And I thought that was a very interesting way to start that conversation. So I'm not suggesting that I have a solution. I'm suggesting that there are problems within the system that I think are being overlooked because we're doing what everybody wants to do, which is to say, it has a screen, it must be a television set. It has words on it and it's printed, it must be a newspaper. In my experience, 20 years in Silicon Valley, when people don't understand the internet, they try to make it look like something they already know. And it's a perfectly understandable way to go about things. Everybody has to start someplace. I myself did it when I was first reporting in the Valley. But we've come a bit past that, and so I'm looking for ways to even the playing field, if you will.
I hear you, and I appreciate your innovative approach, but again, what I'm trying to figure out is, okay, so we segregate out this group of ad buyers and do what? We create a database of them?
Well, I mean, I think it makes, when you say do what, are you talking about how, promulgating rules, or are you talking about sort of practical applications that might take place within the buying platforms? I think that if...
What can we do as regulators in order to better inform voters, which I think is the goal here, where this is about disclaimers and disclosure, because what we're trying to do here is to figure out how to get information to voters about who's behind the ads that they're seeing, right? So, and that seems to be a universally shared goal.
Yes.
Mr. Hochberg says that's his goal, and Ms. Bannon says that's her goal, and most of the people we were talking to yesterday said that's their goal. Nobody at least is coming in here and saying, we want to hide who's behind the ads. They're not telling us that if that's their goal, but so I'm taking people at face value. Okay, so now we've got this an intriguing idea. We've got this group of ad buyers that we know are targeting voters because they have at some point acquired voter data, and they're using that in their calculations. And now, in order to better inform voters about the ads that they're seeing, there's a piece missing in there.
I think that's when you say, here's what the disclosure rules are. And and you can those rules can be a badge in this circumstance. It can be, I myself favor shorter disclosures because I do a lot of business in California, and the committee, for a group of really great people for a really good reason, funded by a really lovely man with lots of money, the disclaimer that goes on forever and ever, I think, is useless. I think the shorter but sweeter disclaimer is in order. But the problem is that in our current system, it is perfectly possible to place political advertising on the internet with no compliance to rules that have been promulgated at the state level and no compliance to rules that will be promulgated at the federal level, even if with the disclosures that we're doing here. And so I see a compliance issue, and I see a situation in which people will feel free to create their reaction to that, which is, oh, well, if you're CNN, you don't take certain kinds of ads. If you're Spotify, you don't take certain kinds of ads. And I see that's my concern.
So what? Just one more, and then
Okay, Steve.
So is what you're suggesting then that we take any ad that is run by one of this segregated category of ad buyers and put a badge on that says
Yes.
this is a political ad?
Yes.
And identify who it's coming from?
I think, I'm a vendor, right? I will do whatever you tell me to do in terms of disclosure. But, California has a perfectly fine system right now. We have a badge on the ads that say who funded this ad, and you are required to provide a one-click through. That, to me, is not a terribly onerous situation. We ask clients to comply with that law. The problem is that Facebook has set up its own regulatory system that's different from that because they lack guidance, I think.
I could go on longer.
I know, I hear
I'll go
you.
all the time.
I hear you. Commissioner Walther, you had your hand up. Do you still have a question?
I think that part of it is, from our perspective, we're here to try and figure out how to communicate or basically how to conceive of ways to communicate in the future. But what you're telling us, I'm not sure resonates with what kind of rules we would implement in order just to, in other words, our jurisdiction is limited to the effect of providing information on a very limited 3 or 4 sentences. And so I'm concerned about, I'm not so really concerned, I'm just asking, the conversation to me is very interesting, but from our perspective, how does it affect us?
That may be. Again, I'm not an attorney. I am really just kind of trying to grapple with solutions to this problem. And as I said in my testimony, this may not be may not be a matter for this commission. This may be something, and I think both CDT and Tech Freedom mentioned the Federal Trade Commission last night. This may be something that has to be legislated. I don't know. My goal here is to simply make sure that the commission understands that as someone who is a vendor, regularly buying and selling political advertising, and only political and advocacy advertising, that we have run into situations where I know I can get undisclosed ads up on the web with little or no friction simply by following a few short steps. I am not the only person in politics who knows this, and that is my concern.
In this particular case, so it's not like there's a enforcement step that's taken. We don't try and inhibit anybody from doing whatever happens on TV or on the internet, if that's what you're getting at.
No, that's
Because
not. No.
what people decide to do is up to them, and then the consequences are up to partially us, but that's how it works for us. So that, and usually as we react to complaints that come in saying there weren't a certain disclosure wasn't made, and then we consider the issue at that point. One of my concerns is how do we deal with the very transitory message where somebody pops up and says vote for Fred, and they're gone, and we have no way of knowing, and we get a complaint saying we got this this advertisement, vote for Fred, and there wasn't any disclaimer, but it's gone anyway and perhaps not preserved. And I'm just wondering if we should have a provision that whatever is a political ad has to retain an electronic position where they save it for a certain period of time. So at least enforceability becomes possible.
I thought
I
yesterday.
address this to anybody.
Yeah,
who
yeah,
might be
no, I
interested in
thought your
it.
suggestion yesterday about a watch, you were talking, I think, when your
Yeah, I'm
grandchildren.
big on watches right now.
Yeah, no,
This is all-
everybody is. They're kind of cool. But you said, I think you were referencing the Mondale exclamation point.
Right.
Yeah, and you said, then you said, well, maybe it could just stream through and have a second screen that said paid for by Walter Mondale for Congress or Vice President or whatever. That's a perfectly acceptable idea, I think. I mean, in essence, what you're saying is that, in this case, it's probably a piece of HTML5 code. But what you're saying is that code has to render two images: one, Mondale exclamation point, and two, paid for by whomever, and that's you can embed the disclosure in the code as it streams through, is what I'm basically saying.
As what? Yeah, I'm sorry.
You can embed the disclaimer in the code that renders the image, the computer code that renders the image, and that seems to me within the purview. Again, not being an attorney, that may well be within the purview of the commission.
To require a retention of that,
Yeah.
you're saying? Well, I think we haven't really talked too much about that aspect of how we're going to deal with the very in and out message. And I'm not too sure how we would do this in the case where we got a complaint and said, where is it?
Yeah.
Oh, thanks. And I welcome the comment from everybody on something like that.
Thank you.
Thank you.
Thank you. I have a couple of questions for Mr. Hochberg. Thank you for coming today. And you note in your comment that the RNC has placed hundreds of thousands of digital ads. And I think you mentioned in the hallway that you're one of the largest ad buyers working in politics now. Is that correct?
Yes, the RNC as well as basically our joint fundraising committee, those are pretty much have to be in the past cycle and a half some of the largest ad buyers.
We really appreciate your coming in because obviously you have a specific amount of expertise that we're really looking for today, so thank you. A couple of quick questions. One, you mentioned on the bottom of page 4 of your comments in alternative B, and I appreciate your comment about bright line rules, no time for an AO, all that kind of stuff. I have the same goals. And you talk about alternative B, while we tried to make that more objective and clear, I completely agree with you that it's still confusing. And the comment that you talk about was, if it does exceed 10% and if it doesn't, and all this kind of stuff, what we were trying to do in the part that you referenced there is our colleagues were raising concerns about our proposal, and they said, well, what if someone tries to put a 10% disclaimer on there and they want to game the system? So instead of keeping it at 10%, they intentionally try to mess with the system and make it a 12% disclaimer, and therefore they would be allowed to go to a truncated, an alternative disclaimer or an indicator. So we put that in there to avoid that, and we thought, well, gee, we fix that, but I agree with you. On the other end, that makes it even more confusing to implement, and you have to get through a lot of different barriers. So thanks for bringing that up. We were trying to make it cleaner, but it may have made it less administrable in the meantime. With respect to the indicator stuff that we've been talking about, on page 4 of your comment, you mentioned your ad choices, the DAA's icon that we talked a lot about yesterday. You mentioned that. Do you think that that's the best indicator to put on an ad, or do you think the FEC should just sort of leave it as requiring an indicator and let the market sort of decide what the best indicator is for the ads?
I would lean towards just requiring an indicator, not specifying which one. For instance, I don't believe Facebook actually has the Your Ad Choice disclaimer available on their ads. They have a different button that they just rolled out that you'll click on and it reveals who published the ad. They have their full database that's now searchable. And then there could be another group that comes up that doesn't have that, your ad label, that they want to use that. Leaving the options up to the companies that are actually displaying the ads is usually the best way to do that. As I said before, there's going to be ad types, there's going to be companies that we buy through, there's going to be new social networks that we don't deal with today. And to force some sort of tech onto them could cause, a stifling of free speech, of political speech at that point, where maybe a company says, you know what, the Your Ad Choice disclaimer, that button, I really don't like how that looks on our page. We're just not going to do political ads anymore. And a whole market segment could be unavailable to us. Or it could be, they easily could say, there's certain things that are just become too onerous for our group, for our website. We don't want to do that. it's become too much of a headache for us, and we're just going to say on this type of ad that we're servicing, we're not going to have a political version of it because it's too difficult for us to make sure we're compliant with this specific piece. And that's a part that does scare me regularly on those, is that there's going to be a very popular ad type that is unavailable to us because of a rule that was very specific towards something that I think a broader scope that accomplishes the same goal would allow us to do.
Do you think that requiring an indicator would prevent you from buying any kind of ad, at least to your knowledge at this point?
I don't think if we said any indicator, I don't know of any company, I can't speak for Google or Facebook or some of the other ones that would put it on there. But that's also why I was leaning towards just any one click away, because most of our ads do go to a landing page. Our ads go to that, and our landing pages have our disclaimers.
Most of your ads go to have a click through to the landing page.
Yes.
Okay, so there's already some kind of, may not be an indicator like the ones we're talking about now, but there's already something on there that allows you to get to the full disclaimer.
Yes, yeah,
Okay.
and that's something that I think is lost. The majority of our ads, our goal is actually to get people to a landing
Right,
page to
right.
sign up for something, to find out how to vote.
Right.
That is our end goal on a lot of those. So, to the FEC rules, we do have a full disclaimer on the bottom of our landing pages. And that's something that we would encourage as part of the ruling, to allow us to continue to do that, because people will then know, when you click through, our ads are meant to be interactive, that they end up at a page that has our full disclaimer on it.
Okay. One of the, two of the different panelists yesterday signed on to a proposed rule text that AFP proposed. One of the groups is Tech Freedom, the one that Ms. Nolan mentioned. They support the proposed rule, and they added, I'd have to go back and listen to the tape, but I think he said adding smart disclosure to it. So I want to get to that in a minute, but that proposal allows the advertiser to put the name or an indicator. So if a platform didn't allow you to have an indicator because for whatever reason they don't like that, or the option is still there for a name. So I think that solves obviously Facebook could change their policy, but right now they require the name at the top and the wraparound type of thing. So even if Facebook doesn't now have an ability to put a disclaimer within the text or the video, it would satisfy that rule because you have the name at the top.
Yes, and that's to our full point on this, is that there's going to be, as I said, in the next 5 to 10 years, so many different ways to display, who bought an ad. And to allow, for the buyers to say, well, as long as I fulfill this requirement somewhere in the ad that I'm buying, that it's at least just one click away from the user, that they can either hover over, there's an indicator on the ad itself, or, when the purpose of the ad is to lead to a landing page, that landing page has the full disclaimer of who bought it. Those pieces satisfy, to us, the need for supplying sufficient information to any consumer, any voter.
Okay, one last question for you. Mostly the press has been asking about the timeline of this rule. That's pretty much all they've been asking. And so if we were able to come up with something, I don't want to get ahead of ourselves here, but if we were able to get up...
Very optimistic here.
I know. I don't read this the wrong way, but if we were able to come up with something, in short order and put out a proposed rule this summer, maybe, OGC is going to pass out, but if that were possible, would it be something, how burdensome would it be for the RNC? Let's just say that the rule is the one that we're talking about, which allows you to have the name or an indicator.
I'll say, depending on the ruling,
Okay.
It could be a lot of trouble for us.
Okay.
What
if it's the indicator?
The indicator, as I said, if it's already worked within platforms and platforms are ready for it, or if it's a one click away, or all those pieces.
But what are you using now? You're using the link.
We're using a link right now, so
Okay.
either a link or the disclaimer in the ad, depending on which ad we're running.
Okay. So if an indicator, I wonder if it could be indicator or a link. But if it were that, then you wouldn't.
It would sasatisfy. Yeah, that would probably be fine.
That wouldn't be burdensome because you're already doing that. But what if, let's just assume for a minute that we didn't allow for a link. I don't see that happening. But let's just say it just says you can have an indicator. you're saying that maybe
It may be. I'd have to take a look to see exactly how all the platforms react to it is kind of the issue that we would run into. I get always worried about any changes late towards
Yeah, I
election day.
totally understand. Believe me, that's
And-
not something we want to do. Is do something that messes up with people's plans right before an election.
And-
I just want to get a sense of.
And I'll be honest, for the RNC, like, we have resources and we've been able to adapt. I have a full team, thankfully, that can figure out things and we can work within the system. What worries me, and this is what we kind of saw a little bit with some of the new ad platforms that were rolled out on Facebook recently, is that it's the smaller state committees, the state parties, smaller committees that are running federal, that would fall under this, under your purview at least, that are running federal election ads, that they may have more trouble than we would.
Okay.
I'd have to, you'd have to ask some of them on that, but we're
again-
usually pretty adaptable quickly. It worries me, smaller groups, that it's maybe, one person who's physically placing the ad. They don't have, they're not paying a vendor. They don't have, the expertise that I'm very fortunate to have on my team of people who are able to handle that type of stuff. And that close to an election day would worry me a little bit.
Got
but
it.
Again, it would always just depend on what the ruling is for there.
Okay, thank you. One quick question, and I'll turn it over to Commissioner Peterson for Ms. Bannon. You have in your comments the 1% click-through, and I just took a quick look at the article. It looks like a very small, limited sample base, U.S.-based WordStream clients account representing $553,000 in aggregate Facebook spending. So can you speak to that? It seems like a very small study. We haven't had anybody else that gave a 1% number.
Sure. Yeah, I just included that just sort of to use Facebook as an example, but I've done more research since then, and the other two people on the panel could probably speak better to the percentages than I can, but looking up like Google's, the average Google display benchmark across all units and formats is 0.5%. So I think it can vary, but it's a very low percentage of the people that are clicking, and I know that is their goal, but
Do you have a comment on that?
Sure. I think to that point, I've heard that a few times. I won't say what our click-through rate is for it. It is low when you look at a percentage, I'm sure. But to that point, I think when we look at it, I hate to make the comparison to direct mail and online ads, but a direct mail piece has a disclaimer usually on the back and the last page at the bottom. It's not, you don't fault the mailer for not putting a disclaimer on the front of a direct mail piece. And for us, it's a very similar thing. An online ad for us is meant to be clicked on. It's meant to be interacted with. You're meant to get to the end of it. And if the end of it is a landing page, then for us that would satisfy that same requirement that you don't have to put a disclaimer on the front of a direct mail piece. If somebody throws away their mail on their way from the mailbox to the door without flipping it over, you don't penalize the person who sent the mail.
Right. And we talked about this yesterday. There's not, I don't think, any studies that show whether or not people are actually looking at the ad. So if they don't click through, that doesn't mean that they read it and decided not to click through. It may just mean that they just scrolled right past it. But anyway, Commissioner Peterson? Oh, I'm sorry. Sorry.
yeah, no, my point with that was just that I think the paid for by and the name of the PAC or the campaign is important to have alongside the indicator. So there's at least some information that doesn't require you to navigate to a different page. So that's where I was going with that.
Okay, thank you.
Thank you.
Peterson.
Thank you, Madam Chair. Got questions for each of you. Let me start with you, Mr. Hochberg. You're the Chief Digital Officer. You're familiar with the technology. You don't have to be in the world of 11 CFR and 52 USC all the time like we are. And one of the issues that we've been trying to gain a better understanding on, and that maybe you can speak to this and the others may want to weigh in as well, is for online users, how comfortable and savvy are they when they are interacting with an ad? And as you said, this is a different medium than static ads that we see in television, radio, print media. that when they're looking at something that they'll know that they can click through to get more information, that if there are icons that they can know that they can click on it to maybe find out more information about that particular ad, who bought it, what further information that they might be able to glean from that particular advertiser. Because, you know, one of the, as I have stated on several occasions yesterday, we want to comply with the statute. We must comply with the statute, which requires certain information be included with certain communications, whether it be express advocacy from political committees, so forth. But we also don't want to discourage innovation in terms of internet advertising, and we don't want to cut off avenues, especially low-cost avenues, for individuals, candidates, and committees to be able to communicate through a medium that allows them to reach a larger audience than they would if they had to rely exclusively on traditional media. So what is your experience and what is your understanding of how a typical user would understand what information they can glean from an online ad?
I think there's two pieces of this. One are the indicators. So that we've been talking about various types of indicators that can appear on ads that, you know, as we said, Facebook or the your ad choices, disclaimers that, or indicators that have been popping up. I think that depends how they look on the ad itself. I would refer to any of those people and how many clicks they get for it. But in general, I give internet users a lot more credit on knowing what's going on their pages than most. Most of our ads, they end with a click here to go to it because, as I said, our goal is to get people to a landing page. And it all depends on what platform the ad is running on. But in general, I would give people a little bit more credit that they know if it's a Google banner ad that's on a random website that they see on the sidebar, that they actually do know that they can click that. And that if they click that, they'll arrive at a page that is presumably paid for by the person who ran the ad or affiliated with the person who ran the ad. And that if it's an election ad, they can go see the disclaimer at the bottom of that page. For us, that's kind of the main point of it, is that people on the internet are smarter than I think we give them credit for. And they know, for the most part, that if they see an I in the corner, that there's an info button there, and they can get a little bit more facts about something.
Okay, good, because it's been brought up by Ms. Bannon and others that the click-through rates are quite low. I'd imagine that's the case with almost all ads. And I'm trying to draw what is the significance of that. Is it that because people don't know that they can click on it for more information, or is it that, and this issue isn't just exclusive to online media, but television, radio ads, or print media? I imagine a lot of people turn the channel when they see a campaign commercial before the disclaimer comes up, because they don't really care about what's being said. Or the same thing with radio, may change the station. You mentioned about how many might just throw away the mail before they even get to the last page where the disclaimer is. And so I'm still puzzling over what significance we can draw from the fact that many ads aren't clicked on.
Sure. I mean, the truth of the matter is click-through rates are low, but so are viewing rates. So is the rate of somebody who makes it through an entire ad. If the ad's more than 6 seconds long, the odds of somebody making it through to a 30-second ad at the end is not the highest, and that contributes to the click-through rate. But also the fact that if we have a 30-second ad that you can click through, you don't have to make it the whole time until you see the disclaimer. I think that gives a user a little bit more control over finding out. They don't have to wait the entire time. They can click out to the page that we're going to. For us, it's all about user control at that point. They control their own destiny. If they want to pause and read a static banner ad for 10 minutes and dissect every piece that we put out there, they can do that. If they want to scroll through it in their newsfeed and basically never see it, they can do that as well. It's really more on the user themselves than anything else on it. But I would just point to the fact that even though click-through rates are low, the number of people who actually see an ad compared to how many times we run a variant is actually low as well. So they kind of go hand in hand.
Okay.
I'd like to interject.
Yeah, if I could ask you, you obviously, Silicon Valley, you've been involved with online ad buying. What's been your perspective on this issue?
I have two things. One, political is unusual in that the sole metric that is generally used is a click-through rate to measure an ad's efficiency and effectiveness. Other brand advertisers have a range of data points that they are happy to trot out for you, and which mean nothing unless someone has gone to the website to look at. Political is unique in that, and most of our clients are heavily interested in click-through rates because, as Mr. Hochberg has said, that's how we collect information and get funding, et cetera. So the 0.1, as a company, our floor is a 0.1%, which is lower than Google's overall, and I believe the 0.5 that Google's referencing includes video and some other types of advertising. We work very, very hard to up click-through rates through a process called optimization. And I'm sure you guys do it too. And what that means is that we are constantly looking at dashboards that tell us how people are interacting with advertising. And we are constantly looking to up those click-through rates. We are starting to see mobile click-through rates that are 1%, 2%, and 3%, which is, we're deeply, we're excited. We're past excited when we see that. And so those sorts of metrics are there. The other thing I would say is most people are interacting with the internet on a commercial basis for shopping or whatever these days. And I think by now most people know that if they see a pretty pair of shoes, they can hit click, and those shoes will be at their door by sundown tomorrow. So I worry less about that. The other thing is I just wanted to interject on the indicator conversation that we were having earlier. There is a danger here that an indicator is going to be used by certain publishers to turn away political advertising. It would be the first clear marking that would occur on the ad platforms. Assuming, in other words, right now political advertising is not in any way distinguished from anything else. There's no icon or badge. If you are to put an icon or badge on those ads as they run through Google, a double-click bid manager, which is the Google network, or Trade Desk, or AppNexus, which is now being bought by AT&T, there is a chance that those ads will be turned down when they reach publishers. I think that chance, and I think Mr. Hochberg is right to be concerned about it, I think there is a very good chance that some publishers are going to say, political, not interested, and block those ads. The net effect will be that people now have to go more directly to publishers, but again, that gets you into my concerns about walled gardens and people setting their own rules.
Yes, go right ahead.
I just wanted to say that, of course, I agree, it's true that with traditional media, people aren't always going to see the disclaimers. But I think the difference is that when you're watching a TV ad, if the viewer doesn't do anything, the default is for them to see the ad. They take the affirmative step to turn it off or change the channel. Whereas if you need to click the affirmative, it's the reverse. The affirmative step is needed to actually see the disclaimer if you just have an indicator. So that's the difference, I think.
Okay, and that goes to the the question is is advertising, video advertising, for example, on the internet the same thing, and should we view it through the same lens that we do television advertising because of the interactive ability? And so that's one of the questions that we're having to puzzle through. One quick question. During your opening remarks, Ms. Bannon, you mentioned that there were certain elements of the proposals that might discourage innovation. Could you flesh out what your concerns were?
So my concern was with the exception in Alternative B that allowed some advertisers to not use an indicator or the full disclaimer. So it was
the application of the small items are impracticable.
Right.
Okay.
Yeah. So that's just what I was referring to, that small part and I think that's been with the IAB yesterday and today. I think now people have seemed to come to an agreement that there should be some way to get to a disclaimer. So it was just to the narrow part of Alternative B that would allow some small ads to not include any form of indicator was what I was referring to.
Just to clarify, the small items and impracticable is not in Alternative B. Alternative B has a new exception. So if you're talking about the exception in so just because I figure you're not as in the weeds on this stuff as we are, what we put in on Federal Register notice. So I just wanted to make sure the record was clear on what we were talking about.
And finally, I just want to just briefly mention that I certainly understand the concern that has been expressed by Ms. Bannon and Ms. Nolan about users wanting to know why they're being targeted for political, for what demographic characteristics are political campaigns and parties finding interesting about them, and why are they being targeted for particular ads. And I think that's, I think that raises issues that are much larger than just politics, but in general about how information is collected about us and what implications that has for personal privacy and so forth. As I'm thinking about it just off the top of my head, the concern I have is I'm not sure what statutory hook that we would have to collect that sort of information. Our law says ads have to contain information about who paid for it and whether it was or was not authorized by a federal candidate. A requirement to then require these ad buyers to also disclose the demographic information underlying those decisions. I don't see how we could do that statutorily, and I could also see a potential even freedom of association issue that could arise from that. I know that, for example, when we conduct enforcement investigations of campaigns or parties or so forth, we can't disclose the file at the end of that, disclosing what the strategic goals and research of that committee were. That for the agency to be prying in and demanding that we receive, strategic information from parties and candidates. I could see that could start running into issues regarding freedom of association, even though I certainly understand the concerns of citizens about how their information about their buying habits, about how they vote, and so on and so forth, are being used by political candidates, parties, and so forth to target them. So I just point that out as a potential issue. But you look like you wanted to respond to that.
Oh, well, I agree. I think one of the things that I have found interesting about the entire debate about political ad disclosures and what happened in the 2016 election is that it's serving as a sort of concentration of all the conversations taking place in the ad tech side of the house, where you have people doing targeting of consumers for consumer good reasons and then going and losing the data and having it spread hither and yon, that people are starting to get very concerned about. And so from my way of thinking, a lot of what we're discussing is problems in how people are approached on the internet for commercial purposes. We're using political language because it is a thing that is the most sensitive to us. I mean, whether I buy a pair of shoes or not is not of great concern to society at large, but whether or not my vote is influenced in an unscrupulous manner certainly is. So we're having the same set of conversations. We're just using different kinds of language, and I do think that there seems to be an interest in some sort of statutory or legislative solution. What that is well above my pay grade, as the former vice president liked to say. So,
thank you.
Any other questions, Madam Vice Chair?
Thank you. I want to go back to a question that we were trying to explore with some of the witnesses yesterday. I'm not sure we still have a good answer for it, but it's kind of key to what we're doing. There was kind of general consensus that if it is feasible, and however we define that, to put the full disclaimer on the ad, then that should happen. And then at some point...
Wait, where was that consensus? Was that from yesterday?
Yeah.
Okay.
Yeah, from yesterday.
Oh.
Both proposals start from the premise that if you can get the full disclaimer on the ad, then that's the first thing that one would do. Mm-hmm. And then it is only at some point, and that's the key question, what that point is. At some point, it is not feasible, and I'm using the word feasible, which is not a word in either proposal, just as a proxy for there is some point along the way where it doesn't seem to make sense, it's not practical, it's not feasible, we can't fit it, it's more than 10%, whatever metric we're using. At some point, we would go to an adapted disclaimer, and there seemed to be general consensus that it was appropriate to do that under some circumstances. Little bit of discrepancy on some people, like Ms. Bannon said, it's really important to get the name of, at least on the face of the ad, of the sponsor, and then the rest of the information could be at a one-click place. Other people said just put a little indicator on it and people will click through. But the question of what is the trigger for going from the full disclaimer to some lesser amount of information on the face of the ad and then the availability of it at a one-step remove, that is kind of a key question that I think we've been trying to grapple with. What's that trigger point? So I would welcome any advice, and I realize this goes in a slightly different direction from what Ms. Nolan is suggesting, but it's if we proceed down the road that we started out on in this rulemaking, it's a decision we're going to have to come to at some point. Any advice you could give us on what kind of metric would be appropriate to use for that decision point?
I'll start, and I understand that this is probably the hardest question to answer on it because anything we say is fairly arbitrary for it, and that's why we've been advocating for the one click away, is because of this fact, is that whether it's 10%, I heard somebody mention 40%, which scares me to no extent at that point, but it's going to be an arbitrary number, whatever gets thrown out there, and the difference between 9% and 11% is nothing on an ad. And that's the difficulties that we run into, and that's why being able to fall back on having a one click away, and that's why I will harp on that forever, is because it gives us that clear, bright line of we know no matter what ad we run, no matter what platform it's on, no matter what indicator is the preferred method on that platform, that we will be able to be compliant with the FEC. And that I can turn to our legal team and say, we are good, that we feel safe in running these ads, and that consumers will know who ran the ad. And that, for me, is the biggest piece of it, is just knowing beforehand that we're safe.
Well, fewer consumers will know. If all of your disclaimers are one click away, then fewer viewers are going to get to that one click point and see that. That's point one. But then if it were on the face of the ad or some version of the name were on I mean, RNC is really short. It's hard for me to imagine there are a lot of places where you can't fit 3 letters. Another point that I think is important to note is that you seem to have a different notion of what the one-click rule means than some of the witnesses that we had yesterday, who said, when we say one click, we mean one click and there's the disclaimer right there, not one click and you get to more, depending on who you're talking to, persuasive information or propaganda from the advertiser that you have to scroll through in order to then find the disclaimer somewhere at the end of whatever amount of information. So there seems to be a little bit of a discrepancy on even what one click means. Ms. Bannon, did you want to weigh in on this?
Yeah, I'll just say I think it is really difficult for the FEC to draw the line with, I mean, I think everyone's really calling for a technology neutral standard so that you're not in this position again in a few years. And I think everyone wants to avoid that, right?
I don't know. A few years is a lifetime in technology. Yeah. Who knows what we'll be looking at in a few years?
Right. So our position is that having the paid for by RNC with an indicator is the best. It's just like the best option. I think that extra information alongside the indicator is the best compromise. And to get the full disclaimer, you can click. We can maybe argue about what one click away means, but I think that at a minimum there needs to be some text on the face of the ad or in the wraparound box on the social media.
Can I just respond to something? So I agree with you that when we started yesterday, that was sort of the threshold question: is how do we figure out how to get from the full disclaimer or an adaptive disclaimer to an indicator, and what's the standard? I completely agree. That's where I started yesterday, but I think we have a little bit of a different take. That to me, after yesterday, because I didn't think anybody had any good proposals for a trigger standard. That we had yesterday. I mean, somebody said if it's not impossible. I mean, nothing jumped out as me as here's the solution that you and I weren't able to find. And we worked on this quite a lot with the Office of General Counsel. I mean, the proposals that we put out took a lot of time and attention from those of us who are very familiar with these issues. We didn't just throw out the first thing that we thought of. And so those trigger mechanisms didn't really work for a lot of the commenters on both sides. And as I say, I don't think we heard anything yesterday that sort of solved the puzzle. And because of that, it seemed to me that people were moving in the direction of at least considering having just the indicator on the face of the ad with, you know, the full disclaimer available at the landing page. That's what I took out of it. And
well, some people came in with that perspective, such as Mr. Hochberg.
Right.
I'm not sure that anybody yesterday said, "Oh, I was thinking it would be better to have the full disclaimer," but you're right. As long as you have an indicator, you could have no information.
Well, I do think I'd have to go back to my notes, but I do think that there were a couple of panelists who came in, you know, with, you know, you got to have the full disclaimer no matter what. And it seemed to me that they were a little bit more, as the day went on, more receptive to the notion that maybe you could have an abbreviation of the name, or maybe you could shorten the name. I agree with you that not everybody said, oh, just go with the disclaimer and you'll be fine. But I do think that there was some... Oh, yeah, sorry, just go with the indicator and you'll be fine. I do think there was some movement away from the rigidity of having the full disclaimer on the face of the ad. But I do think that there were a number of panelists who seemed to move in that direction, and a couple who specifically endorsed it in their comments, you know, after seeing two different proposals. But I do think your question about the one-click, you asked about what's the landing page, and I've thought about this a lot, and I think that, you know, yes, there are a few bad actors, and a couple people mentioned them yesterday, where if you link, it goes to some unknown, you know, crazy web page. But putting that aside, because I think it's a pretty small percentage of bad actors, if you click on the RNC's link, you're going to, I think, you go to the RNC homepage, which they're not hiding who they are. I mean, it's very clear of what they are.
I'm not worried about the RNC.
And, no, okay, or any of these other political committees, and it's going to tell you right up front who they are, which candidates they're supporting, what their issues are, that sort of thing. Whereas if you link to some, you know, box there that says paid for by the RNC, 310 First Street, and here's our website, and here's our phone number. I mean, I just don't think that, and I do think we heard this from some people yesterday, that disclaimer information in and of itself doesn't really give all that much information. You know, mom and pop apple pie or whatever it was that someone said yesterday in the street address just isn't doing it for me.
I agree with you, but that's what the statute requires. I would like it if the statute said you had to provide more information. I think that if mom and pop apple pie PAC are appropriately filing their reports, then somebody who is really curious can go and find out who their donors are and get a better sense of who's behind the organization. We're dealing with the statutory framework that we have, which requires certain language on a disclaimer, and the issue that was raised was, is it one click? And like I said, I don't think anybody's confused about who the RNC is. That's not a big problem, I think. And I don't think that you're trying to hide who you are. But there's two separate issues. One is the malicious actors who are actually trying to hide who they are. And the other is just how easy is it for voters to access the information? And if we say you get to it in one click, do we mean you get in one click, there's the information that the statute requires, or one click and now you can start hunting for the information that the statute requires? Those are just two different, I just wanted to surface that there are two different ideas about what that means.
Thank you for our name ID being so high and, and no concerns on our ads lately. And to that point, I think it was mentioned that there would be no problem when, you know, there's space to put paid for by the RNC on an ad. And some people may know what that means. I think there's a lot of other groups that have acronyms that they would love to be able to put on an ad as they're paid for that shows no trace of who they are. And I don't think it provides any extra step for the consumer that would, any extra guidance that actually may be more confusing than just allowing for a one click away, because somebody's, you know, acronym may have no association to who they are. But if you click on an indicator or go to their website, you see that at least the disclaimer with at least their full FEC registered name. So now, that's one of the points I would like to make on that.
Let me ask you, Ms. Nolan, because you are from California, so maybe
I'm actually from here, but that's
okay. Oh, you're working in California, though,
yes,
right?
Ma'am.
I'm glad you're from here. This is a great place to be from.
Eastern Shore.
The great state of Maryland. One question that I asked yesterday, and the person that I asked had no really information on it is under the California system. It's my understanding that there are, particularly with, maybe it's with SMS technology, or there are certain kinds of ads where you put the ID number of the committee, and then people can go to the FPPC, California Fair Political Practice Commission, page for that committee ID number and find out all sorts of information, including who the donors and all that are. But the ID number itself is not terribly informative to somebody who doesn't go to the trouble of doing that. So I just wanted to see what your reaction is to that kind of a system, in terms of whether it's effective in getting useful information to voters.
As vendors, our concern is first that the ads are displayed in a way that helps our clients. So the FPPC has promulgated a couple of different rules. I am not familiar with the exact one that you're referencing. Okay. I can tell you that what they have historically asked us to do is make sure that the words "paid for by" appear on every ad. It is a legacy brought over from the rules for direct mail. We have not found their process to be terribly onerous. What we do have problems with is paid for by, long disclaimer, including for primary funder disclaimers that go on at great length, and which we joke and say the really good people doing really good things for a really great reason, paid for by a really great guy with lots of money. So the FPPC has, in fact, and has required us to put numbers on stuff for mail. Right now, what we're doing in California is we have to have a banner on the ad that says who funded this ad. And the use of the word funded is kind of interesting because you don't really ask if Amazon funded the ad that says Amazon on it. You don't ask if Coca-Cola funded the ad that says Coca-Cola on it. So I think the who funded this ad is in many ways a trigger to say, oh, it's political. That said, again, we're vendors, and our concern is about the efficacy of the advertising. It's not necessarily about what disclosure and disclaimer is required of us. We're going to obey the law. I just wanted to circle back a little bit where you were talking about mischievous web developers and people. Most of those.
So that's not you.
No, actually it isn't. One of my board members likes to joke that we are the only ad for tech firm in the entire country that never took any money from anybody outside the U.S., and it's true. But to the mischievous actors, voter targeting was very much a part of the outrageous activity that took place in 2016, and the use of voter files was certainly part of that. So I would just suggest that people who are concerned that bad guys aren't going to put disclaimers on ads, we could take a step back and look at it from that lens and sort of say, well, if you're a bad guy and you're using voter data, then perhaps we can get you as you're coming in the door as opposed to after the horses. Well, that's mixing metaphors. I'll stop there.
I appreciate that point, but I want to circle back and just confirm or put an exclamation point on something that you said before, which is that as somebody who's got a lot of experience in this field, you don't find it onerous to have a requirement that says paid for by with some version of the name on it.
No, I do not. And that is, honestly, that's the requirement that Pandora makes. It's the requirement that most people who are unfamiliar with either federal or state law will ask us to include in ads. We do business mostly on a direct basis. So we often have to go through standards and practices at places like the New York Times, the Washington Post, and the Los Angeles Times. Our concern is that in absence of guidance, as I said earlier, in absence of guidance, these folks are making up their own rules, and they're trying to out Facebook, if you will. But one of the minimal requirements is paid for by, and we can generally default to paid for by. And we have also used mouse over or hover ads as well for the lengthier disclaimers. We would hate to see that option go away. It is one that we find useful.
If everybody has another couple minutes, I'd like Commissioner Walther has a question.
I just had one question of Ms. Bannon. That was, you said something that's a lot more stronger because we're micro-targeting, because of the micro-targeting. But how does that affect us?
Sure.
Because the question, the micro-targeting, and I feel like I've been micro-targeted a lot lately. I had one article that I was interested in. I hovered in this one store, electronic store, and it keeps coming back to me now for every time I open up my computer. But you said, why would micro-targeting make a difference? In other words, does it make any difference to us whether that message was sent to Fred or George or somebody that likes a Prius or somebody that likes something else.
So I think, so the reason I emphasize that is that the rationale for having these disclaimers, in my mind, is a lot stronger because of the micro-targeting, to know who paid for it. And because if you're seeing an ad online, it was targeted at you for some demographic, some sort of information about you, and to know who paid for it is even more important than if you just turned on the TV and everyone in your area is being served the same ad. So just the rationale for having the disclaimer, I think, is stronger than it even is for traditional media.
Right, but that doesn't affect our decision as to whether or not to have it, because we have to have it.
Right.
So I just wondered what that different that makes.
Well, yeah, one other thing is just that, like, when there is an indicator and a landing page, this may fall outside of your statutory hook for this, but that same mechanism is also the place where you get the full disclaimer and you also get that demographic information. And that's similar to the ad choices system.
Thank you.
Thank you very much. Thank you very much to all three of you. I think we, once again, could keep talking for another while, but this was incredibly helpful. Thank you so much. And we'll start the next panel at 11:05, just 5 minutes late. Thank you very much. Good afternoon. Thank you for being here for our fifth and final panel.
Still morning, it just feels like it.
Did I say good? It does feel like afternoon. Right, sorry, good morning. On this panel, we have Theodore Peterson, Digital Director of the National Republican Congressional Committee. We have Thomas Riker, Deputy Digital Director, National Republican Senate Committee. We have Carmen Scurato, Vice President and General Counsel, National Hispanic Media Coalition, on behalf also of Asian Americans Advancing Justice and Color of Change. Thank you very much. As you may have heard, each witness is permitted to give a 5-minute opening statement. The yellow light will come on when you have 1 minute left, and then the red light will come on when it's time to wrap up your comments. We'll go alphabetically, so we'll start off with Mr. Peterson.
Good morning,
Morning.
and thank you for the opportunity to participate in this hearing. Each of us serves in the digital departments of our respective national party committees and devotes substantial time and resources to digital communications. And we're happy to offer this statement jointly today. The issues raised in the rulemaking are issues that we have seen firsthand. Our two committees' lawyers have submitted written comments and told you what they think the law requires and allows. We're here today to address some of the more practical considerations before you, and we want to emphasize how important it is that you pay as much attention to the practical issues as you do to the legal issues. For practical reasons, both of our committees believe strongly that the overriding consideration for any internet disclaimer rule needs to be flexibility. Flexibility encourages compliance, and flexibility ensures that we can continue speaking as we see fit.
To this end, we want to emphasize 3 points. First, the proposals in the rulemaking are efforts to apply old law to new technology. As you know, technology seems to evolve at the speed of light, and that is certainly true in the digital communication space. The disclaimer rules in the statute are from the early 2000s, and they were written with TV and radio ads in mind. The Internet rule from 2006 was written primarily with graphic website advertisements in mind. The proposals currently under consideration are responses to social media and applications typically used on handheld devices and tablets. But Facebook is not the last digital platform you will see, and iPhones are not the last devices that will be connected to the Internet. Any new disclaimer rule you adopt now will become obsolete sooner or later, and the only way to avoid having to repeat this exercise in a few years is to be flexible now. Second, the FEC should not adopt a new rule if there is uncertainty about whether these proposals offer improvements over the existing rule. The existing rule has been and can continue to be applied flexibly. Our committees have never been under the impression that new media digital advertising is exempt from the disclaimer requirements, and we don't do ads without disclaimers. If we can't put the disclaimer on the face of the ad, we use the click-through approach. We're not aware of committees out there that have a different view. Among regularly reporting committees, we don't think there's a disclaimer problem. Third, there are some proposed requirements in this rulemaking that would render certain advertising formats obsolete. If the practical effect of a disclaimer requirement is to kill off a type of messaging, it's bad policy. It's one thing if Congress mandates this, but another thing altogether for the Commission to choose it where the other options exist. One example is the proposal to extend the stand by your ad requirements to online videos. This requirement is not compatible with the 6-second online bumper ad, which has proven to be an effective way to capture people's attention and drive efficiency. If we have to devote 4 seconds to the disclaimer message, we simply won't run 6-second ads. This is just one example, and we raise it with the hope that the Commission will pay special attention to how these rules will apply in the real world outside the book of regulations. Thank you.
Thank you. Ms. Scurato?
Thank you. Today, online communications provide valuable opportunities to engage in the electoral process and allow disenfranchised voices to be heard in innovative and powerful ways. Technology has evolved exponentially since 2006, and online platforms now have sophisticated methods of tracking users. Advertisers are provided information to target specific audiences through detailed profiles of their preferences and habits, and can tailor ads to exploit weaknesses and biases. When used for political advertising, these technologies pose a threat to our democracy. Because of these tactics, voters are susceptible to deceptive campaign practices that attempt to spread confusion, discourage voters, or disseminate false information. Effective disclosures can alleviate these harms. The 2016 election exposed social media as the Wild West of online communications, where some advertisers targeted online communications to inflame racial hatred and divide the voting public. That is why the Commission's proceeding to eliminate the loopholes left by the 2006 era political advertising rules could not be more critical and more urgent for communities of color. Without disclosure requirements that bring transparency to all online political communications, campaigns will continue to exploit communities of color through voter suppression tactics. People of color are particularly harmed by the lack of comprehensive and effective online disclosures because they are more likely to depend on smartphones to access information about elections and political campaigns. A Pew Research study found that Hispanics and African Americans are 155% and 67% respectively more likely to depend entirely on a smartphone to access the internet than white individuals. Southeast Asian and Pacific Islander Americans have some of the highest rates of poverty among all racial and ethnic groups and even lower levels of broadband adoption. But Asian Americans who are connected lead the U.S. population in the use of the internet, mobile digital devices, and social media. 91% of English-speaking Asian Americans own a smartphone compared to 66% of white individuals. But the Commission's current rules do not require that every political ad these individuals see on their smartphones have a disclosure. Inadequate disclosures fuel misinformation campaigns and contribute to voter suppression tactics targeted towards people of color. That is why it is critical that the Commission move forward to provide clear rules for online political ad disclosures or risk further disenfranchising already marginalized communities. One place to start is a definition of public communication. As the Commission suggested, the definition should be revised. We agree. But the rules will be ineffective if they are not written to capture the dynamic online space. That is why we propose additional language so that the final rule reads communications placed or promoted for a fee on another person's website or internet-enabled device, application, or services. The promoted for a fee language would capture influencers who are paid to share content created by others, where no payments are made to the platforms. Or services language would apply to the entire online ecosystem. For example, Netflix or an online video game might be better understood as online services than a website or application. As for the alternatives, we generally support Alternative A and support the creation of an adapted disclosure exception, but the Commission must make clear that the political advertisers can only use this adapted disclosure when complete disclosure on the face of the ad is simply not possible. An adapted disclosure will only be effective if it is a uniform indicator with a message that clearly signals that it can be used to access a full disclosure. The full disclosure should not be accessible in no more than one step, and it should not include any other information than the disclosure itself. For the indicator, we suggest paid political ad, but we encourage the Commission to select or support an indicator that meets the same standard of effectiveness as the ad itself. An indicator would not be effective if it were just a website URL. Additionally, the Commission should extend the clear and conspicuous requirements to online disclosures. Rules for printed medium require a reasonable degree of contrast and sufficient size to be readable. The Commission should also clarify that for a disclosure to be clear and conspicuous, it must be in the same language as the ad. As stated earlier, people of color are clear targets of deceptive practices that attempt to spread confusion and discourage voters. This proceeding is about having an informed electorate in the digital age. It is about ensuring that predatory online ads are not weaponized to sow division and hate in our society, further disenfranchising already marginalized communities. It is about securing the integrity of our electoral process. It is about protecting our democracy. Thank you for the opportunity to be here today, and I look forward to your questions.
Thank you very much. Appreciate it. Any questions? I'm going to start with Commissioner Walther or Commissioner Peterson. Commissioner Peterson.
Thank you, Madam Chair. A question that I've asked of other panels up to this point is what can we expect an online viewer of ads to be savvy about in terms of when they're interacting with online ads? I think that across the board, and the Vice Chair brought this up in the last panel, we agree that there is, at some point, at a minimum, there's some point where there are online ad formats that just can't accommodate the traditional disclaimers that we see on radio, television, mail, newspaper ads. And when we reach that point, and we've struggled to find, a trigger where we'd go from the full to the to more of a truncated, an adapted disclaimer or an indicator. But I think there's general agreement that at some point that there are some ad formats that are valuable to committees, to candidates, to individuals to be able to reach audiences at low cost that we don't want to discourage, that would require an indicator. And so what can we expect of the average? How familiar, from your experience, are users with interacting with ads, understanding that there may be click-through capabilities, that there are icons that can inform them about additional information? Because if it's the case that viewers are relatively knowledgeable, that they can get the information that that is required under the statute through a simple, either a hover, rollover, click through, click on an icon, then that would allow kind of the best of both worlds, where the actual content of the speech is not impeded by or overwhelmed by the disclaimer, and that the disclaimer doesn't get cluttered up by the speech, and that each element that is necessary for an effective communication is there. And so I'll just start with Mr. Peterson and just ask each of you if you could respond to help educate us on this particular concern.
Absolutely. Thank you for the question. I think it's a common understanding that regardless if it's a political ad or an ad for merchandise or what it might be, that a click of that ad will lead to more information. A click will lead to a website, which will lead to more information. We've heard a lot about the indicator from previous panels. I think my biggest issue and something to consider about this indicator is that, can it be platform agnostic? Can it be screen agnostic? We're talking about, we've heard a lot about Facebook and Google and Twitter, but not a whole lot about Snapchat or Hulu or Vivo or Amazon or Pandora or Spotify or Apple TV or Xbox, and I could go on and on, right? There are so many different formats and platforms and ways that people are connecting to the internet and getting these ads. Can that indicator be agnostic to all of these different types of formats?
Okay. Mr. Riker?
I think your question implicates the need for flexibility in the approach to this problem, because the real answer is it completely our ability to serve a full disclaimer versus an adapted disclaimer versus whatever indicator you all might be considering is completely dependent upon the platform itself, and not only the platform but the ad type. And so I think there's almost a limitless number. The only limit to the different types of ads that can be served on the internet is the limit to Silicon Valley's innovation, right? So I don't feel that I can predict all the different units that are going to be available in the next 5 to 10 years, and I certainly don't think that that's a thing that could be codified into regulation, so there needs to be flexibility to speak to the fact that there are constantly new ways that people are interacting with the internet. However, I will also say that I know for both of our committees, we disclaim on any advertisement that we run on the internet. Everything goes through legal approval. We do our absolute best to incorporate a full disclaimer where we can, and if it needs to be adapted, we do our best to make sure that it is very clear that we're the ones that are speaking. So it's not really an issue in our sphere. We disclaim on every ad that we run, and if we can't get to a place with both our legal counsel and the ad network where we are able to serve a meaningful disclaimer, then we won't run that ad. So I have struggled to foresee a situation in which someone receiving one of our ads wouldn't know that we're the speaker because we go out of our way to disclaim.
Ms. Scarrato?
So I do agree that we need flexibility, but I think for me, that's when we talk about the platform itself and the new types of digital media that will be available in the future. We just can't potentially see what that would be. So that's why we really think that or services language is necessary to capture that. For example, a service could be a video game, or what you were talking about, Xbox or Hulu or Netflix, other ways, other means that people are receiving these ads, and that's why it's important to include that language. And I also think that you mentioned the click over or the hover over feature, and I really want to emphasize that we have to think of solutions that are also available on mobile devices, especially when we're talking about people of color who over-index on mobile, because that is not, you don't have the rollover hover feature on a smartphone. And I think that would then preclude that disclosure from ever popping up if you're looking at it. And I think that's an important thing that we need to consider. One of the things that we also did in our comments is that we actually proposed some language that may capture these new technologies. So we think that it should read a digital public communication with text or graphic, and this is when we're talking about the adapted disclosure, but without any video or audio components that due to the character or space intrinsic to the technological medium cannot include the required disclaimer. So we think that, again, captures that forward-looking, and is that forward-looking approach that is needed to understand that this is important across all platforms.
Okay. You brought up in the discussion on public communications that you would like the definition to include advertisements that are placed or promoted for a fee. I don't know when it happened, but at some point in the last few years, I've gone from being, I thought, relatively with it and in the mainstream to being kind of over the hill, as my kids constantly remind me. So I'm aware of promoted tweets and promoted posts and so forth. I see them, in a Twitter timeline or on a Facebook feed, but I'm not at all knowledgeable about how that process takes place. You mentioned, I would have just assumed that there was a payment that would have been made to Twitter, made to Facebook, and I understand that it can be as inexpensive as $1. You could do it for $20 or however much. Walk me through a little bit more about how the promotion process takes place, so that I can better understand how that would even work in terms of the disclaimer requirement.
Sure. So with this promoted for a fee language, what we were trying to capture is when individuals are being paid to promote content. So you're talking about influencers, you're talking about other agents. And so what we thought this was important is that if you don't have this language and someone is being, again, paid to promote content, you're just having a surrogate, right?
And how do you arrange, how does one recruit an army of influencers and make a payment for them to promote a particular post, a particular news article, or what have you?
I will be honest, I'm not familiar with that process, but...
Not to put you on the spot, it's just something that's come up a few times that I hadn't really thought about, and then I'm just trying to gain a little more understanding of.
But I think it's important to look at the Federal Trade Commission's guidance on this, because they require that bloggers, reviewers, and influencers who get compensated to promote a specific product actually disclose that they were paid to do that. And that's very important because people do rely on these individuals, and they do trust them, and it needs to be clear when they are being paid to show that product, or else it could just be, for example, I could say, I really like this Coach bag, right? But if I'm being paid by Coach to say that, that is a very different understanding, especially when you're viewing it as a consumer.
Okay. And finally, I'll start with you, Ms. Scarrato. You mentioned in your opening statement that you would want any indicator to be uniform across platforms. And I guess one of the questions would be, because I think some concerns have been raised by other panels about that we should put the requirement for an indicator or signifier or logo or icon of some sort, but not be overly prescriptive about what that looks like, what it says, to allow innovations and allow for some flexibility for that process to develop. But I just wanted to give you a chance to explain a little further why you think that should be uniform, and rather than allow there to be a few different modes by which an indicator could be provided depending on the platform.
So in our comments, we actually said we support paid political ad as the indicator, But there's been, I know throughout this, this hearing, there's been variations of that, but we think paid is a very important part of that. And I think the reason that we want something that is clear, straightforward, and consistent is that helps inform the electorate, right? If we have variations on the same thing, you were talking earlier about the need of an individual to understand, can they click on this and what information they will get? And I think having something, again, that is consistent across platforms, whatever that indicator may be, is very important to that process.
Do either of you have anything to add either on the issue of educating us on promoted posts or promoted tweets, or on the issue of indicators and the uniformity or the need for some flexibility in that realm?
I mean, I would just reiterate that on the actual advertisement itself, we disclaim on any advertisement that we run on the internet, and in some potentially foreseeable instance in which that wasn't possible on that ad, maybe we would rely on click-through, which I think is also a decent disclaimer and speaks to the mobile experience as well. But we disclaim on every ad, so this would be additional, an additional disclaimer for us. And I would also, I also would just note that it's one thing to talk about language that's uniform across all platforms, but to talk about an actual impromptu or some other form of like marking that is uniform across all platforms is just not technologically feasible. So.
I'll start with commenting about the influencer disclaimer. It's not something that we've, that I'm familiar with, but I would say that anytime there is a new ad format, anytime we have a new way of trying to communicate to voters, there's a very rigorous process at both of our committees where we go through our legal department and they're making sure that we are complying with the FEC rules. And that would be the case for this influencer situation too. Again, I'm not sure how that transaction works, but we would be going through a rigorous process to make sure that we're following the rules.
Okay.
Secondly, on the indicator, Ms. Garrido mentioned the mobile device, and I think this indicator is certainly I think the way you're thinking about it is it's a hover over, right, or something you click on. But again, on a mobile device, that's not the same user experience as on a computer. And we have people on smart TVs or Roku or Apple TV who are seeing these ads. And again, those are not situations where you can necessarily hover over. I'm not sure if you're familiar with the ways to access those types of smart TV consoles or Apple TV. It's like a clicker. So you're not able to hover over that. So I guess the point I'd make is it needs to be flexible for all these different types of ways that people are accessing the internet.
Okay. Thanks. That's all I have for right now.
Can I address just one thing real quick? And you said it's not technologically feasible to have something, and I think that is something that the platforms are more equipped to really speak to at this point, because the way that I understand it, especially when it comes to these platforms and the language that we proposed about the disclaimer being intrinsic to the technological platform, would not compel these companies to require that, but it would incentivize them to create some technological mechanisms in order to accommodate political ads.
Commissioner Walther, do you have any questions? Or
No, not at the moment.
not yet? Okay.
I got the impression, though, that the gentleman from the party before indicated that there was click-throughs that you've used.
I think
But is that, am I missing that?
some of the RNs, the gentleman who was here from the RNC mentioned that he if he didn't put the full disclaimer, he sometimes had the link to click through to the RNC webpage. Is that what you mean, Commissioner Walther?
But then from my conversation today, I didn't get the impression that you were using it. You
Oh,
always get
Again,
the sense that-
we're anytime we're using the point that I was trying to make about the Apple TV not being able to hover over, or the point I'm trying to make is that we just need to be flexible in how this is implemented, because there's so many different types of ways people are accessing the internet. If it becomes something that is limiting our ability to use the other types of advertising platforms, then in my mind, it's limiting our ability to get our message out.
What are some of those that are being used now that you're referring to?
Well, so OTT, over-the-top advertising, is a new type of digital advertising where there's ad inventory available through an Apple TV app, an Xbox app, a Roku app, right? And these are ads that could be playing on a TV, they could be playing on a smaller screen. But these are the types of technological advances that, in my mind, requires the disclaimer rule to be flexible for us to try to comply as best as possible with the rules.
So how would it work so that anybody that clicks on, say you have a handheld and along comes a message, so you're saying to click through with your computer, you can do that and automatically get to another page. Is that the idea? And it would be just one page that says, or first of all, let's clarify. Do you do that at all? Because I got the impression that everything you did was...
Almost every form of online advertising is clickable through to some sort of landing page. Right. That's the nature of online advertising. Right. It is to incentivize an interaction with the viewer. But we disclaim on the actual front-facing ad on any advertising that we run, and on platforms where that needs to be truncated in any way at all, we work with both the platform and our legal counsel to make sure that it's still abundantly clear that we are the ones who are speaking.
All right, so you modify the language, but you don't have a click-through.
It would be both. It would have anything we do has a disclaimer, and most things we do are likely clickable through to a website that also has our full disclaimer and our name on it.
Okay, so
belt and suspenders approach.
So that would be an add-on, but do you have anywhere you just have an ad, and you have a little message or an icon or something, you click, and then you get the information about who paid for it?
It would typically for us, it would click through to a landing page, but so to a standalone web page that has our disclaimer on it in addition to whatever other information. But the actual front-facing ad would have our disclaimer, and then I believe what you're talking about is clicking clicking some sort of icon or impromptu, and then having a pop-up that says this ad was paid for by whoever. Facebook and Google are both currently working through at a technological level what they want that to look like, but that's a thing that the networks are already tackling right now.
Okay, so if I understand it then, in every case you've got, and when you see the message, you also have the full text of the required language or a modification of it, but you don't provide that somewhere else.
We do
unless
both.
It's, unless
it's on the ad, and then also if you clicked the ad, then it would be on that page.
Yeah.
But I cannot think of a time in my time at the committee that we have ever run any online advertising that did not, on its front-facing creative, have a disclaimer letting people know that we're the ones who are.
Well, we had a discussion with that gentleman.
But wait, Steve, I'm sorry to interject. I think when he says disclaimer, he doesn't mean the full disclaimer. So I just want to, that's what I think, there's a bit of a
That's
disclaimer.
okay. I'm good, thanks.
No, go ahead.
No, I think I've got enough information.
Steve, I'm sorry. I was just trying to.
I'm doing good. I'm fine.
Okay, I was trying to clarify when Mr. Riker was saying that we disclaim on every ad. I just want to make sure that you're not saying you put the full disclaimer on every ad. I think what you're saying is you do to the extent you can, but if you can't fit the full disclaimer, you might have a shortened version of it. But that I think you said you always link to your home page.
That's correct. And as far as the linking, I was just saying that's the nature of online ads. Like the networks incentivize you to have an ad pull through to a page because it's an interactive experience. So that's, yes, that is the thing we do to disclaim, but it's also just a thing we do because it's an online advertising best practice. If we're going to serve an ad, it should be clickable and drive to a website where you can take further action to engage in the political process.
Do you have some instances where you have just your website? You can click on the website and get to, and obviously your website would probably have NRSC in it, but do you ever have that link where you can get to your homepage?
I cannot think of an example off the top of mind where we don't have additional disclaimer language.
Okay.
Like I can't think of an example where we just have our website. So.
Okay. Madam Vice Chair.
Thank you, Madam Chair. So in the ads that you are currently running, when someone views them on mobile devices? Or do you have ads where you can see the full disclaimer on the mobile device?
Yes, we do.
Okay, so that's good. So that plainly means that it is possible to do that because you're doing it.
With respect, it's so specific to the actual advertising experience itself. So not every mobile ad is the same. So just because there are some mobile ads that are sized large enough that you could legibly and without interfering with the ad experience serve a full disclaimer does not mean that something that's 120 pixels by 120 pixels and is a banner ad at the top is the same viewing experience. That being said, we still work with the networks and our legal counsel on those ads to make sure that there is still a disclaimer. And again, it would almost always, I cannot think of an instance in which it wouldn't also click through to a website with our full disclaimer.
Okay, so just want to make sure I've got this right. So on the ads that you're currently running, when people look at them on their mobile phones, some of them, they get a full disclaimer when they're looking at it. Some of them, there's some information, and you click through to the full disclaimer on a landing page. Is that an accurate depiction?
Yes, I believe so.
Good. Want to make sure I got my facts straight. And I should have said at the beginning, thank you again, all of you, for coming. We really appreciate your technical expertise. And Ms. Garrato, I particularly appreciate your being here because you are providing a perspective that none of the other witnesses are providing, and one that I think is really important for us to be cognizant of how what we're doing affects voters writ large, but also voters in different populations. And your written comment was really very helpful to me in trying to sort through some of those issues. How important, now you've indicated preference for alternative A, and you've said that you think the full disclaimer should be there unless it's really impossible to have it on the face of the ad. How important do you think it is, particularly for the people who are going to be viewing the ad on a mobile device? And let me just say that I do almost everything on my mobile device. I have laptops, but I don't know, I just always end up looking at things on my phone. How important do you think it is to have the full disclaimer with all the legal requirements versus having paid for by with the name of the sponsor and then a click-through or some other way of getting to the full legal language?
So I think that depends, again, on the medium, even on the cell phone, right? Because there are different platforms, different apps, and you view them very differently. Some people even have bigger iPhones or bigger smartphones and smaller ones, right?
Yep. Go for one of the smaller ones.
So I think, again, it really just depends on that, and I think we would lean on having the full disclosure whenever possible, unless, again, it's just that medium does not provide enough space or enough characters for that disclosure. So that's why we really think that's the most important thing, to have the informed electorate, and especially when you're talking about, and I know this was brought up, I believe it was yesterday, about having ads travel across the internet ecosystem. And when you have ads travel across the internet, having the disclosure on its face is very important versus that click-through feature or that adaptive disclosure.
And when you talk about the promoted, capturing the paid ads where the payment is for promoting it. I mean, right now when I look at ads, I will sometimes see in my Twitter feed, for example, the word promoted is, up there in the corner of the ad. Are you thinking about something like that? Or are you thinking about, promoted by X person, or, paid promotion by, what can you spell out exactly how you envision this would look?
So this would be, again, for payments that are not made directly to the platforms. It's payments that are made to individuals to promote that particular content. So I believe the disclosure would have to say is paid for by, very similar to you would have on any other political ad online.
I think I must be getting tired. I think I'm running out of questions. Although, well, let me ask the
I was
question.
going to say that's hard to believe.
I know, it is hard. Okay, one more. I'll ask the same question that I ask everybody, because I do think this is really one of the key questions that we're going to have to come up with some answer for. And because many of our witnesses, I don't want to categorize, I think most, but certainly many of our witnesses have expressed preference, like Ms. Corrado, for having the full disclaimer information. But most of them have also acknowledged that there would be some circumstances in which that might not be possible. And at that point, we would have to have some kind of an adapted disclaimer in order to get the information to the voters. So one of the key questions that we have been trying to grapple with over the last couple of days is, what's the trigger point? At what point do we say, okay, that's, you know, if I'm looking at the ad on my screen and the entire screen is now filled up with disclaimer, is that too much? Is that the point where you have to say, well, an adapted disclaimer would have worked better in that circumstance? But at what point do we move to the adapted disclaimer and move off of the full disclaimer? What do you think the optimal rule for that would be?
Again, I think it depends on the platform, and that's why we wanted to include that language, that it has to be intrinsic to the technological medium that is being used. But I do want to emphasize that I believe a percentage trigger is not the right solution, only because I think it would just lead to some absurd results when we talk about a candidate's name, for example. Like if I use my full legal name, Carmen Elisa De Stefano Scorado, maybe that allows me to have an adapted disclosure. But John Doe, as in your examples, he would not, right? And so I think we have to consider that. And also just even changes in language. I think the example that we use in our comments, if you said paid by color of change, that may not require an adapted disclosure, but if we said paid for by color of change, depending on the medium, that may trigger that. So I think we just really have to consider where are these ads being placed and then go backwards from there. And that allows, I think, for that flexibility when we're talking about the advances in technology that we'll see in the future.
Yeah, and I think that's that concern that, you know, some people, that mischievous actors might come up with a long name of their committee just so they would avoid ever having to do the full disclaimer, or they might choose larger typeface in order to fill up more than 10%. I think the difficulties using a percentage-based calculation and the problems with, well, you know, why do you have one answer for 9% and a different answer for 11%, even if you could, you know, parse it all out that way, have been pointed out. But again, if we're not going to use a percentage base, then what's what are we going to use? I think there needs. I think we need some kind of a metric for that, but I would be open to any suggestions.
I would just add that we don't think there's a problem. We are putting disclaimers on everything that we put out on the internet for a fee, and the burdens of any new requirement are going to fall on those of us that are already following the rules, and the bad actors, if they're out there, they're still not following the rules. So we're the ones that are going to be affected by this, and we're the ones that are already following the rules, and we do not believe there's a problem.
And that leads to something that I wanted to ask. Thank you for reminding us that there are current rules right now. A lot of people seem to think that there aren't, and I think that's something that Ms. Scorado said at your opening statement. I think you said that there aren't rules now on the internet. Correct me if I'm wrong, but I got that impression from what you said. And
so that's not what I meant.
Okay.
I meant that they don't cover all forms of ads across the internet ecosystem.
Well, I think they do. I think we have a disclaimer requirement for all internet ads, and that's in our regulations. We had a recent AO that reiterated that. We do have an AO that was promulgated a few years ago, the Google AO, which provides for an ability to use a link, and we've talked about that a couple of different times today. So I don't think that our rules, current rules, have anything to do with which platform you're using. And your suggestion that it depends on which platform with respect to what disclaimer and what standard we use, a lot of other commenters and panelists have said that's not workable for them because they often create an ad and they don't create it for a specific platform. They create something that they then want to place in a lot of different areas, and so the notion that they're going to have to create something and run through the traps of 10 different platforms rules or our rules for 10 different platforms just isn't workable for them. So I just want to let you know that that's something that we heard, but there are rules, and it's good to know that you guys are following them. One of the other things I wanted to, do you want to comment on that?
But I can wait.
Good.
Thank you. I think that perhaps I'm glad we all agree there are rules, so that's good.
Yeah.
That are currently in effect. I think perhaps what some of the witnesses have highlighted is that there may not be perfect compliance with the rules right now. The RNC, I'm sure, is complying with rules and putting disclaimers on everything, but there may be other groups out there that are not complying, and you mentioned the Google AO. The Google AO was, of course, one where we agreed that what was happening under the specific circumstances, using the specific ad platform that Google was, I think it was AdWords, that Google was using, subject to the technological limitations and abilities of that tech platform at the time, what they were doing was okay. That's really all that AO said. It didn't say, and everybody under all circumstances can always use a click-through as a substitute for putting the disclaimer on it. It doesn't say that.
I'm sorry, it doesn't say what was
it does not say that everybody under all circumstances can use a click-through in order to avoid putting a full disclaimer on it. So so that's good that we have agreement on that. But I think it's more of a compliance problem than a requirement problem, which I want to give you an opportunity because I can see you want to say something about that, but I also want to at some point ask the witnesses if they have suggestions for us as to how we could promote better compliance and promote better understanding that really these are the rules and everybody has to comply with them.
Well, I'm glad you brought up the compliance issue because that's something that a number of people in the panels yesterday, Paul Ryan, Brendan Fisher, and Professor Kim all talked about that. And I asked Professor Kim several questions about this because the first panelist referred to her work, and then we had an opportunity to talk to her directly. And I asked her to supplement the record because I haven't seen yet any ads. Maybe she has them appended to her study, and I wasn't able to pull them, that show that a political, somebody who's governed by our rules of paying for a political ad with express advocacy didn't include a disclaimer. And I'm sure there are people, and I told you last season that there's a guy right down my street who has a big billboard at his diner, and he said, vote for Hillary Clinton with no disclaimer on his billboard. So I'm sure we could find yard signs, billboards, all kinds of examples of people who aren't complying with our disclaimer rules. That wouldn't surprise me, but I think the number of people who are doing that is incredibly small. And I think the notion that we're building up this premise that there's all these people who aren't complying with our rules and therefore we have to change everything really is not on firm foundation. And that's something that I was trying to tease out with the witnesses yesterday. And when I asked one of them, which ad specifically can you show me? He wasn't able to offer a specific example. He said, speak to Professor Kim. And so she hopefully will supplement the record with the kinds of ads you're talking about. But I think, again, the notion that, A, there are no rules, which we've just dispelled there are rules, and B, the notion that there's all of these people out there who are taking advantage of it, just, again, is on faulty foundation. And that also, the issue we talked about briefly yesterday, the notion that the Russians are taking advantage of all of this. The Ms. Scarudo, did I say right, referenced the USA Today article on page 10 of her comments that the Russian-based Internet Research Agency placed 3,500 Facebook ads, and that's based on information that was released by the House Intelligence Committee. But what's not included in your comments is that USA Today took a look at those 3,500 ads, and only 100 of them, was it 100 or? Yeah, I think it was 100 of them referenced either a federal candidate. And of those 100, I'm not even sure, I haven't looked at them myself, but I'd be surprised if all 100 of them contained express advocacy. My guess is that most of them did not. So you're talking about a very small number of ads, and I think a letter we received from Senator Klobuchar yesterday references that the Russians paid $100,000 for ads placed on the internet. And again, I don't know how many of those contain express advocacy, but we're talking about how much did the party committee spend in the last cycle? I mean, $100,000 is a minuscule amount of ads.
As a competitive U.S. Senate race in a state of 1.3 million people, I spent $2.3 million in online advertising. So
Can you say that again, please?
As a competitive U.S. Senate race in a state of 1.3 million people, I spent $2.3 million in online advertising. So
Just in online.
Yeah, so I can't speak
That's
to...
in one United States Senate race. You spent $2.3 million. And the United States Senator is writing us about Russians spending $100,000 on online ads. I don't have a calculator, but that's an incredibly small percentage.
I think we also have information that the Russians were spending millions of dollars on trying to influence
On things that,
election.
but on issue ads that we have no jurisdiction over.
Well, I think that's somewhat debatable over whether we have jurisdiction over ads that are placed for the purpose of influencing an election by a foreign government. But that is not what
we're talking about here.
That's definitely not what is within the jurisdiction of this rulemaking, which was from the start crafted to be very narrow, and I was thankful to be able to get anything to this point in the process. So that was the trade-off, that we're doing something that's very narrow. But I think what happened in the last couple of years is, because of the publicity over this, people became very sensitized to the notion that they are not necessarily knowing where the information is coming from that they're seeing online. I think it is not an accident that the first couple of times we put the notion of fixing our internet disclaimer regulations out for public comment, we got 6 comments and 7 comments, and when we did it last year, we got 150,000 comments. I mean, people are just more concerned now about where the information is coming from that they're seeing, and they want to make sure that, to the best of our ability, we are providing that, requiring that information. So I think that is part of the concern that is underlying this, and
I agree with you that there's additional concern. However, I think part of that is because people, and I think that the press plays a role in this. People are putting out information that's just not true. We do have rules on internet advertising, and most people are complying. So I think if you start out with the wrong foundation, you can understand why people are concerned.
Well, I'm not sure about the wrong information part, but I will go back to my question to the panel, which is, how can, if you have any suggestions for us as to how we could not only better inform the public about where the information is coming from that they're seeing on their phones and on their tablets and laptops, but also how do we better inform the folks that are placing the ads about the requirements and making sure that, as we all agree here, so that's great. People say we never agree at the FEC. We all agree there are currently rules that require disclaimers on digital ads. So that's great. How do we get that? Do you have suggestions for how we could better get that message out and make sure people understand those rules? Because particularly for people like you at the RNC, I would think, you are complying with the rules. You know what the rules are and you're complying with them. I would think you would want everybody else to be complying with them so that you are not at some kind of competitive disadvantage.
I just want to clarify, because it's happened a couple times. Neither of us work for the RNC.
Yeah.
I'm sorry.
So, but you're right. Like for both of our committees, we can say we are doing everything we can, not doing everything we can. We disclaim on every online ad that we run. I would look at what the networks are doing, particularly Facebook and Google. Facebook has already rolled out its reporting tool, which will no doubt go through a variety of changes. Google is in the process of rolling out theirs, which will no doubt go through a variety of changes, which I think implicates the need for flexibility in whatever rule is set here. But the network's already taking the lead on this, and I think right now today you can go to a link on Facebook and look up any actor who is governed in the political sphere and who is meeting disclosure, not even meeting the FEC's disclaimer requirements, but who just lists their own name on their Facebook page, and you can find whatever ads they are currently running paid. So the networks are tackling this problem. They are no doubt going to impose their own requirements regardless of what this panel does, and we would urge flexibility for that reason, among others.
So one of the things I wanted to go back to is what we support is having that full disclosure, and that would alleviate some of the concerns that you raised about having a different ad depending on the platform. By far, that is our approach, is that we do believe that the full disclosure should be on the face of the ad. Again, if it travels across the internet ecosystem, which ads tend to do, that would alleviate any of the concerns of the adapted disclosure being also intrinsic to that medium. And also just the fact that we do think that it should be, when you do have that adapted disclosure, it should be clear, it should be straightforward, and it should really trigger for individuals the importance of that adapted disclosure, that you will get further information about who paid for this ad and why you are seeing it. So one of the things that was mentioned yesterday was from CDT, that they support studies that maybe that's where we need to go in terms of the adapted disclosures, like what is that right symbol, what is that right that right thing that we need to embed in these ads that need the adapted disclosure. That is something that we do agree with, and maybe that is where we need to go to get to the right solution.
I also think it's worth pointing out that one of the things that both proposals had suggested was some modification of the language in the public communication definition, which right now only addresses paid advertising on websites. So arguably, somebody could make the argument that it doesn't apply if it doesn't show up on a website but only shows up on an app or on some other in some other digital format. So I think that actually would be a helpful improvement to the rule.
Okay. Any other questions for the panel? Commissioner Walther? You doing good? Commissioner Peterson? I think that brings us to the end of our hearing. Thank you very much. That was very helpful information and conversation. Thank you to all of the FEC staff who have helped us throughout this hearing, the Office of General Counsel, Lisa Stevenson, Aaron Klopak, Jessica Selenkoff, Nevin Stepanovic. Thank you particularly to the four of you. You've done a lot of work, and it'll be fun working with you over the next few weeks and months to hopefully come up with a final rule. Thank you to those of you who helped bring people up from the lobby and greeted them with warm faces. Thank you to Laura Sinram who helped us facilitate the whole meeting, and thank you to our IT division who have been here both all day yesterday and all day today, and there's others from your division listening. Mr. Palmer recommended having you guys available because a lot of this technical stuff that we may be a little bit harder for us to grapple with. These guys know what they're doing, and they can help confer with us afterward on how to craft some of this stuff.
And Jim Jones, who has kept this up on YouTube, and people who want to, sort of chew through this some more, can go to YouTube and go to our website and find a link to that to listen to the whole thing all over again.
That's right.
And also, believe it or not, there were leftovers from lunch yesterday, so I want to invite everyone in the room and anybody in the building until the sandwiches run out to join us in the conference room next door.
Did you want to reiterate that the record's going to remain
Oh, yes,
open?
thank you very much. Should we say a specific amount of time? The records are going to remain open if anybody wants to supplement the record from witnesses only, from witnesses for the next 2 weeks. Does that sound good? 3 weeks? 2 or 3 weeks.
And if anybody who's not a witness wants to weigh in, feel free to send it. It'll be an ex parte contact.
And also to our offices, all four of our offices who have helped throughout this process, and I think in particular to Amy Rothstein and Tom Moore, who have sort of been the leaders on our side on this. But that doesn't mean that all EAs haven't been fabulous, and we appreciate all of their hard work. So thank you to all of you. Appreciate it.
Do you want to bang the gavel and adjourn?
Oh, sure. Let me bang the gavel. There we go.